Tony may be able to sue your company in negligence for the personal injury and pure economic loss suffered from the harm he experiences. The basis for this claim is the eye damage and resulting loss of sight for Tony, which leads to pure economic loss. However, it is unlikely that pure economic loss will be established by the court, as this may lead to a floodgate of cases. Potential negligence is a seeming lack of efforts by your company to ensure repairs were intensively cleaned before allowing employees to perform this standard. Unfortunately, potential liability for your company may lead to damages to be compensated if causation is established. The actual damage Tony can claim for includes any impairment of his physical condition as is defined under Section 38, subsection 1 of the Limitations Act. In determining whether the proof of substantial damage element made essential by Rothwell v. Chemical Co., the harm results in a considerable change for Tony through the loss of sight at the cost of your actions. The actual damage results from the small stone landing in his right eye as a consequence of the potential negligence you cause. It is likely that the court will view the injury Tony experiences as a life-altering one, with the results of medical treatment leading to the loss of sight. The extent of the harm is illustrated through this inhibition to continue in his profession. Is a duty of care present between your claimant and the company? Under Wilson's v. English, employers have an undelegatable duty of care to ensure a safe system of employment. While recent cases such as Fairchild v. Glenhaven have determined a duty of care in these relationships, there is still a lack of a clear and objective rule for employers. This may be beneficial as the courts are more likely to take a contextual approach to your case. Some identified duties you should have ensured are employing competent employees, cleaners in this circumstance, providing adequate materials, and a safe premise to work. Your company should have assessed the potential risk of injury to employees which could have ensured the remaining stones from the stage which would have prevented injury. If further evidence of attempt to fulfil these obligations, then you may rebut the arguments under the duty of care. There are exceptions to the general rule of no liability for omissions. Counsel for Tony may argue under the assumption of responsibility of Barnett for Ministry of Defence, as your company should have regarded employee welfare which could have prevented the injury Tony suffers. The creation of a dangerous situation arose in Haynes v. Harwood, meaning the lack of adequately cleaning up after stage repairs and allowing employees perform appears to suffice a dangerous situation. It is irrelevant whether a third party conducted the repairs or your company yourself, as under Smith v. Littlewood, it remains your responsibility to ensure the repairs were rectified. Did your company breach the duty of care? The standard to test whether your company is liable for the omission is the reasonable person test from Blythe v. Birmingham Waterworks, which is divided into two questions. How your company ought to have acted under the circumstances. In any situation, a reasonable employer would have cleaned the repairs as in accordance with statutory and common law guidelines. How did your company act? It was reasonably foreseeable that certain conditions are required for stage performance, meaning the possibility of harm for Tony could have been prevented. In considering whether the medical non-disclosure suffices as a breach of the duty of care, under Greg v. Scott, negligent medical procedures must have caused Tony's survival rate to fall from over 50%. His injury is non-terminal. It appears that you owe a duty of care to Tony, and once an employer is found to have breached their non-delegatable duty, it is necessary to establish causation between the breach and the harm. The causation element is broken into two limbs, factual and legal. Factual, under Barnett v. Chelsea, the court will ascertain whether but for your company's negligence would Tony have suffered an injury that required medical treatment. Tony also had a short window to be treated due to the possibility of blindness. A doctor's actions can be found negligent but cannot be established as actual damage. It seems that on the balance of probabilities, your company caused the injury and substantial physical change Tony suffers. The injury experience was incurable. The doctor was simply able to attempt to lessen his symptoms. Tony can argue, but for your negligent act, he would not have required medical treatment, meaning the court are likely to view your contribution to the harm as more than 51%. Difficult where non-disclosure could not be classed as grossly negligent, which was established in Robertson v. Post Office. Legal. If your actions on the damage suffered by Tony are viewed as too remote, or an intervening act has broken the chain of causation, your company will not be liable. Remoteness of damage. Under Rag and Mound, this asks whether your company should have reasonably foreseen the damage to Tony at the time of the breach. While you may not have apprehended the specific harm, Hughes v. Lord Advocate demonstrates that so long as some form of a harm was foreseeable, the extent is relevant. It was reasonably foreseeable that the negligence of leaving the stage to remain from repairs could have caused injuries of the most severity for employees who must perform in controlled circumstances to ensure their safety. Intervening acts. Under Robertson v. Post Office, for the court to consider an intervening act, it must be an unforeseen resulting act of the initial harm. Therefore, it seems unlikely that non-disclosure and medical treatment will be viewed as an intervening act, as it is an expected consequence of an eye injury. Knightley v. Johns provides authority that an intervening act should be an unnatural consequence, while commonly workplace injuries require medical treatment. However, legal causation may still be found in the circumstance of medical non-disclosure, as in Chester v. Asphalt. If the negligence is gross, such as the risk of paralysis, causation will be established. It is uncertain whether the court will class experimental treatment without informed consent as grossly negligent. Defences. Through the Contributory Negligence Act, the reduction of the damages to be compensated by your company may be possible, although it requires Tony's acting contributor through medical treatment to be voluntary and informed, which seems unlikely as Tony did not gain full disclosure. Likely to be liable for the injury Tony suffers. Claim 2. Maria may be able to sue your company for the negligent exposure to a toxic substance while Bernardo was employed as a stagehand plumber, which transposed to Maria through his employment uniform. Asbestos exposure is generally related to mesothelioma. However, it must be determined whether previous precedents may apply for Maria's differing form of cancer, which affects the skin. Employers owe a duty of care to ensure a safe system of work, although must be established whether this duty stretches to Maria. Potential negligence may lead to damages to be compensated by your company for the harm Maria experiences. The actual damage from Maria's claim is covered under Section 38, subsection 1 of the Limitations Act as a personal injury, including any disease or impairment of the physical condition. The harm she suffers will cause skin damage and has the potential for the loss of life. As detailed previously, a claim of negligence requires proof of damage through the authority of Rothwell v. Chemical Co. Therefore, it must be considered whether there has been a substantial change of a physical condition. Arguably, suffering exposure which leads to a progressive condition that is possibly terminal suffices actual damage. The court will then consider whether your company is liable for the injury due to the reported conditions/asbestos levels within the theatre. Maria has developed mesothelioma, which progressively damages the skin and may be terminal, which may have been preventable. Through her husband's employment, it appears there are detectable levels of asbestos within the piping, which would have significantly affected Bernard and Maria as a plumber that experienced direct contact with the toxin. It appears there is actual damage, as your company could have prevented the harm through regular testing and protective equipment, reducing the potential for harm. Can a duty of care be established even though Maria was not directly employed? It is likely the court will utilise Capri v. Dickman for this unique and novel situation, which applies in exceptional circumstances where there is a gap in the case law such as this. This allows considerable discretion for the court, making it difficult to establish with certainty which arguments will succeed. The test has specified conditions. A. Was Maria a reasonably foreseeable risk of your company's actions? Asbestos exposure is an ambiguous method of illness. However, it seems clear such fibres could transport to employees' homes, leading to a more extensive amount of harm from the negligence. Evidence otherwise of equipment, safety, or testing will rebut these arguments. Proximity. This is judged on the standards of geography, time, and the relationship between Maria and your company. The court will balance the specific duty towards Maria and the general duty for employers such as yourself. This claim has the potential for a floodgate of cases within this area, since employers would employ a person and assume a duty of care for all living relations. C. Fair, just, and reasonable to impose a duty. This is relevant to the harm Maria suffers. This seems to be the toxic exposure of asbestos without adequate safety equipment. Breach. If the court can decipher breach, then it will be imposed against your company. The reasonable man test under Blytheview Birmingham Waterworks decides how your company to have acted in the circumstances. Potential negligence was preventable through protective equipment, safety testing, and following health and safety guidelines for employers. How did your company act? There are many elements utilised to illustrate the breach and a lack of regard for employees. Under McGraw, if employers are aware of the risk, then it can be held liable for secondary exposure of asbestos. Arguably, Bally companies typically use older buildings, which are more susceptible to the toxic substance, so you should have been aware. Causation. Factual and legal. Both can be applied to ascertain whether your company caused the breach. Factual is likely that the court will use a variation of the but-for test from Fairchild v. Glenhaven, as it also illustrates a multi-employer claim for asbestos exposure. This is the test of materially increasing the risk of harm, which is found means Maria will be entitled to full compensation from that party. The conditions include evidentiary gap. Maria suffered from invisible illness, such as a McGee v. National Coal Board, making it impossible to determine which employee materially increased the risk of asbestos exposure. Appears the evidentiary gap suffices. The only certainty within the condition is that the risk of cancer is increased through more exposure. Materially increases risk. LBC may have contributed to risk, although her husband was employed under your company for 10 years longer, which may have made a more substantial period of exposure if evidence is accepted. Harm caused by the risk created by your company and as a single agent. Maria contracted the illness through negligent asbestos exposure due to the toxic fibres within her husband's employment. Under Barker v. Chorus, damages may be reduced under the Law Reform Act to the period Maria was exposed, resulting in proportionate liability between LBC and your company. Hennigan v. Manchester Dry Docks provides authority that a form of cancer cannot be covered by Section 3 of the Compensation Act, but can still apply Fairchild principles, while also ensuring proportionate liability under Barker. Factual causation appears to be established, meaning a reduction in damages may be beneficial. Remoteness test of the Wagon Mound for legal causation, whether the harm suffers was a reasonably foreseeable consequence of your company's negligence. The harm Maria suffers directly related to the negligent asbestos exposure. It is certainly that employees would be harmed and could extend the harm to living relations. While asbestos exposure is directly linked to the lung cancer, it is unclear whether current precedent will apply to Maria's form. However, since there is a direct relation of the mesothelioma, it is likely the interpretation will be extended. Ambivalent whether the court would establish precedent of Maria's case as living relations would have the same protection as employers and employees. Intervening act is likely Robertson v. Post Office will be applied to demonstrate that it is difficult to ascertain whether exposure through willing touch of Bernardo's uniform could qualify as an intervening act. If the court views Maria's illness as similar to the one concerned in International Energy Group v. Zunich, then Section 3 of the Compensation Act will be applied, likely meaning joint and several liability will be enforced against your company. Your company will only be liable for all the damages owed to Maria if LBC is found completely non-negligent, which appears impossible as both companies use similar buildings. Defence's Contributory Negligent Act may apply as Bernardo chose to work for LBC in similar conditions for 10 years after the employment with you. However, he was unaware of the extent of the risks. Seemingly, Maria's claim will most likely be successful.